Okay, so now in today's class, we'll move to structured formula basis, chapter 3 under module 7. We had completed up to no fault basis, section 140 to 144 earlier. So structured formula basis is basically covered under section 163, 163B and the schedule. So this provision allows compensation to be calculated based on established formulas, removing the need for proof of fault while simplifying the compensation process. So basically, the compensation is calculated based on established formulas. So there is a table in the schedule which is given, and that particular is followed for the sake of calculating the compensation. And there is no need for proof of fault also required because this is anyways under no fault liability basis. For example, if a family member is killed in a motor accident, so the compensation might be calculated based on a structured formula. So there will be a formula which will consider that the deceased age, what was the income, and then a fair compensation amount is calculated. Also, maybe a victim who is suffering from permanent disability from an accident can receive compensation calculated according to the structured formula, thus simplifying what would otherwise be a complex and lengthy process. So this is covered under these two sections, 163A and 163B. So let's read the sections first. So 163A section is a special provision as to payment of compensation on structured formula basis. So this is section 163A. And section 163B is option to file claim in certain cases. If claim has to be filed, then 163B has to be used. So let's see 163A first. So the subsection 1 says, notwithstanding anything contained in this act or in any other law for the time being in force or instrument having the force of law, the owner of the motor vehicle of the authorized insurer shall be liable to pay in the case of death or permanent disablement due to accident arising out of the use of the motor vehicle compensation as indicated in the second schedule to the legal heirs of the victim as the case may be. For example, for the purpose of this subsection, permanent disability will be the same meaning as in Workman Compensation Act. We have spoken about the permanent disability in the last class, that either one eye, both eyes, 1 ear, both ear, or the limbs are gone permanently. So in the subsection 2 says, in any claim for compensation under subsection 1, the claimant shall not be required to plead or establish that the death or permanent disablement in respect of which the claim has been made was due to any wrongful act or negligence or default of the owner of the vehicle or vehicle concerned or of any other person. So basically, any law which is established at this point of time, it talks about. So anything contained in this act or in any other law for the time being in force or instrument having the force of law. So instrument having force of law is any kind of procedure, any kind of rules around any act. So anything which is having a force of the law, the owner of the motor vehicle of the authorized insurer. So the authorized insurer, the owner of the motor vehicle of the authorized. So authorized insurer, the person, the motor vehicle owner who has got that authorized insurance done through an authorized insurer. So insurer should be some leading insurer which is allowed and authorized by the law to be an insurer. So it cannot be an insurer who is a private person and claims to be an insurer. It has to be properly under all the regulations which is concerned to establish an insurance company. So that authorized insurer shall be liable to pay. So when we say, last time also I mentioned, the owner of the mobile motor vehicle is always allowed, is somebody who has to pay the compensation. Now, in all the cases, since last, I think 2023 onwards or 24 onwards, I don't remember exactly. I think 23 onwards, it is made as per the new Motor Vehicle Act, it is made a crime to not have an insurance. It was a defect earlier. So before 2023, it was a defect that if you don't have an insurance, you might be penalized for that. That you don't have an insurance, you go ahead and you pay from your own pocket. Or you might not be able to sell your vehicle with the right price, etc., etc. But on 2023 onwards, it is a penal offense if you don't have an insurance. So insurer has to be definitely attached with every car through insurance, and that is, if not there, it's a punishable offense. So that is why the owner paying means the insurance company paying, and that is why it is mandatory now. So the motor vehicle compensation as indicated in the second schedule to the legal hires of the victim. So if the person is dying, so that compensation will go to the legal hires of that particular person. And the permanent disability is defined in the Workmen's Compensation Act and also in the Motor Vehicle Act, which we discussed last time. And the person need not for the claim. So why this has been done? So of course, this is a structured formula basis related sections, but this is a liability for no fault basis in motor vehicle accidents. Why this is kept that way? Because until and unless you don't keep it that way, the person who is number one, the person who has met the accident, who has suffered or who has died, will have to wait for a long time to maybe sometimes years also to prove who was at fault. And it is very difficult to prove in the motor insurance situations to prove who was on fault. We in India also, it's far more difficult because we don't have that much of camera coverage and those kind of dash cam and etc. We are not having all those things. So it is very, very difficult. And that is why understood for all the countries also have almost the same policy. So in no fault policy, it is kept for the sake of protection of that person who is meeting the accident, either a person walking on the street or somebody walking on another vehicle, whatever it is, the person will not have to struggle to get a compensation for his relief. That is the reason this was done, and it makes perfect sense when we also integrate it with a mandatory insurance policy. Then it makes it 100% successful that when there is no fault has to be called in that case for this is for compensation only. Huh? Keep in mind, we are talking about tort, so we are only talking about the aspect of compensation. So in hit and run cases also this is applicable, for any such cases this is applicable, but we are talking from perspective of tort here. And that is why we are saying it is not, this is being a tort of no fault liability perspective. There is no fault which has to be seeked or looked or proved to ensure that that particular uh, person was at fault or not to seek compensation. Compensation is irrespective of that. While as a second, uh, 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 you know, uh, point on the same subject, it is basically it's a penal offense also. So then the second aspect, which in real life, when you claim in the MACT court, the motor vehicle tribunal, when you go and you put a matter there, it is for the compensation you put there, and that is what is discussed here under Motor Vehicle Act. While a hit and run case matter might also attract a penal attraction from the various criminal laws also to punish that person. But we are only talking about tort here. Now, the part three of the same says the central government may keeping in view the cost of living by the notification in the official gazette from time to time amend the second schedule. So the schedule, so how this is normally calculated in real world is when a person who is taken a hit, there are a lot of very good Supreme Court and Bombay High Court cases on this around this, where the compensation, how it is calculated. People, when make a claim, they have to make a claim. You have to make a claim upfront in this particular under this section, and the court will come back with a reinforcement of the amount which has to be compensated based on this structured formula basis claim. And then they will make that claim depending upon what was the lifetime perspective, what are the liabilities, what was the educational level, and what could have been the person earned if the person would have been alive, if there were the responsibilities which have to be completed. For example, the loads, the debts what the person is having, the kids that person is having, the living style that person had, the kind of cost of living the person is having. So all those things are kept in mind, and a compensation is calculated that way. So it will be very difficult. Different for compensation for a person who is a 70, 80-year old, and a compensation for a person who is a 30, 40-year old. So compensation is in direct proportion to what is the amount of earning and the liabilities the person is holding. And for that, the central government cost of living, they have kept a schedule for that, which is used to calculate this. Okay. Now, 163B says option to file claim in certain cases where a person is entitled to claim compensation under section 140, we have read last time, on no fault basis, and section 163A, he shall file the claim under either of the said sections and not under both. So the person has to claim on either of the sections, not both of them. So if an application for payment of compensation is pending under section 161, forward the particulars as to compensation awarded by the insurer. So for the purpose of this subsection, application for compensation under section 161 shall be deemed to be pending. If such application has been rejected till the date of the rejection of the application, and in any other case till the date of payment of compensation in pursuance of the application. So basically it says that the claim could be seeked only under, relief can be seeked under only one of the either sections, not both of them. I'm just seeing if I can show the schedule to you. Okay, I'll share that with you later. So the very famous case laws in terms of this this example of section 163B(a), which is the structured formula basis. So let's proceed with that, which is Exide Industries Limited versus Union of India is again one example in this case also, in this example also. Basically, let's take another one because Exide we have taken another example. Let's take Sanjeet Singh, SANJEET, Sanjeet Singh versus Oriental Insurance Company Limited. It's a matter of 2010. SANJEET, Sanjeet Singh versus Oriental Insurance Company Limited, 2010. The court held that the structured formula should be applied to ensure a fair compensation for the victim based on predefined parameters like income and age. So basically income and age, and actually the other liabilities are also taken care while we talk about these kind of compensations and the structural liability. So let's move forward to the next point. I'll share the schedule with you attached to the document. That will help you to read it. So next part is compensation, especially in hit and run cases, which is 161 and up to 163, 161 and 163. Let's read the sections first. So 161 says, notwithstanding anything contained in any other law for the time being in force or any instrument having the force of law, the central government shall provide for paying in accordance with the provisions of this act and the scheme made under subsection 3, compensation in respect of death or grievous hurt to persons resulting from hit and run motor accidents. So the subsection 2 says, subject to the provisions of this act and the scheme made under subsection 3, there shall be paid as compensation as follows. Number A, in respect of the death of any person resulting from a hit and run motor accident, a fixed sum of 2 lakh rupees or such higher amount as may be prescribed by the central government. So it says a fixed sum of 2 lakh or such higher amount which may be prescribed by the central. So minimum 2 lakh plus any, in case of central government has prescribed anything, it has to be followed that way. In respect of grievous hurt to any person resulting from a hit and run motor accident, a fixed sum of 50,000 rupees or such higher amount as may be prescribed by the central government. Subsection C says the central government may by notification in the official gazette make a scheme specifying the manner in which the scheme shall be administered by the central government or General Insurance Council, the form, manner, and the time within which application for compensation may be made, and the officers or authorities to whom such application may be made, the procedure to be followed as such officers, or authorities for considering and passing orders on such applications and all other matters connected with or incident to the administration of the scheme and the payment of the compensation under this section. Subsection 4 says a scheme made under subsection 3 may provide that a payment of such sum as may be prescribed by the central government as interim relief to any claimant under such scheme. And number B, a contravention of any provision thereof shall be punishable with imprisonment which may extend to 2 years or with fine which shall not be less than 25,000 rupees but may extend to 5 lakh rupees or with both. And C says the powers, functions, or duties conferred or imposed on any officer or authority by such scheme may be delegated with the prior approval in writing by the central government by such officer or authority. Now, 161 is a special provision as to compensation in case of a hit and run case. So, for this purpose, 162 and 163 section also, a grievous hurt will have the same meaning as in the defined in the IPC or the BNS now. Hit and run motor accident means any accident arising of the use of the motor vehicle or motor vehicles where the identity whereof cannot be ascertained in spite of reasonable efforts for the purpose. And scheme means the scheme framed under section 163, which we'll just see just now. So notwithstanding anything contained in this, all the insurance companies, the agents of them, the council of them, they have come back and under uh, the Central Insurance Corporation of India formed under section 9 of the said act, and the insurance companies for the time being carrying any general insurance business India shall provide for paying. So which means any company which is formed as per the proper rules and regulations of the insurance company which are made, those companies are liable, and these are the penalties which are required to be done, and the calculation has to be done as discussed in section 163. 163 says the scheme for payment of compensation in case of hit and run. So the central government may by notification in the Gazette make a scheme specifying the manner in which the scheme shall be administered, or by the General Insurance Corporation the form, manner and the time within which the applications for compensation will be made, the officers or authorities to whom such applications made may be made. The procedure to be followed by such officers or authorities for considering and passing orders on such applications and all matters connected with or incidental to the administration of the scheme and the payment of the compensation is a scheme made under subsection 1 may provide that a contravention of any provision thereof shall be punishable with imprisonment for such term as may be specified, but in no case exceeding 3 months, or with fine which may extend to such amount or may be specified, but into case exceeding 500 rupees or with both. The powers, function, and duties are conferred on any officer by scheme is as per the central government gadget, and any provision of such scheme, any operate with retrospective effect from a day not earlier than the date of establishment of the solatium funds under the Motor Vehicle Act 1939. So basically what it says that in such cases, whatever the compensation is happening for the hit and run case, there are a couple of key elements around that. What are the key elements which is given under section 161, which is a special section for hit and run, and which talks about what it talks about? It talks about then when the compensation happens, what is a hit and run case, what is a grievous injury, and what is the provision. The provision for the compensation for which we are very much interested is done through the central government notification. So we studied about 163A and in A about the structure being part of the schedule which government keeps on publishing time to time. So the central government keeps publishing the scheme in how the calculation has to be done, what is the rate, what is the age, what could be the standard compensation which can be calculated, and all those things are part of the various schedules which is used. And this can be for which who is authorized is to the officers who are authorized to whom such application may be made. That is also given there, and the procedure has to be followed as per given by the passing order. Considering any passing order on such application, the procedure is also clearly said. While we talk about the interim relief also, and we talk about the punishment also, which could be done in case of either together with the fine or without the fine. So in this case, 161 to 163, which is compensation to hit and run case, the law is actually providing a mechanism for compensation in situations where the identity of the driver responsible for an accident is unknown, and ensuring that victims are not left without resource with that. So even if there is a hit and run case where somebody flees the scene and remain unidentified, so whom you will go and sue, whom you will go and take money from? Hmm? So in that case, they can apply for a compensation under Section 161, ensuring that they are financially supported despite the offender's absence. Even the offender is not present, then also the person gets compensation. For example, a pedestrian is injured in a hit and run case. The accident he can claim from the compensation fund created by the Act. The Act has created a fund, the fund which was mentioned some moments back. So the fund, when it is created, so that fund is a relief to the people where there is no possibility of finding the person who has done this accident, and offering financial relief in spite of that, in needing the without the need of identifying the responsible party. Then also the person can get. The very famous thing was Sahib Singh versus State of Haryana. So Sahib, SAHIB, Sahib Singh versus State of Haryana. It is a 2006 matter where the court has emphasized the need of compensation to be awarded swiftly to the victim of hit and run accident, supporting the provisions in the Motor Vehicle Act. So in this matter, the court suggested there are options available through the central government by notification in the official gazette, which is where the schemes are specified. Like there are multiple schemes, right? If in the government for various other provisions for getting rice, for getting petrol, kerosene, and all those things. The very same way, there are schemes which are given depending upon various criteria. So that is administered by the central government or the Central Insurance Council. So there is a Central Insurance Council, which is a government body. So they have got the scheme which is created and published through the central government, and the form, manner, and the time. So in what form, what manner, and within what stipulated time you have to make that application for compensation is something uh, to be made is mentioned in those schedules, and the officers are authorized to whom such application to be made is also part of those schemes. So the procedure and whom to make the application, everything is given there, and the procedure how it will be followed by the such officers also once they receive the application for considering any passing order such application, etc. So all this matter is part of that scheme, and this is administrated by the government, central government, and the money is basically coming from the centrally secured fund under this particular fund, which is called the Solatium Fund under the Motor Vehicle Act. So this Solatium Fund is something which is then used to give the money. Other famous case in this sense is Oriental Insurance Company Limited versus Mahesh Kumar. Oriental Insurance Company Limited versus Mahesh Kumar, 2007 matter. Oriental Insurance Company Limited versus Mahesh Kumar, 2007. The court has ruled that favorably for the victim, saying that the timely compensation using this government fund must be provided even when the driver is not identified, and it makes far more important for the courts to swiftly run and provide the instructions to the government bodies to ensure a quick payment is done for hit and run cases where there is a no identification of the person who has committed the crime, and the person cannot be leave in a lurch without any support from the government, and that is where the important of this hit and run compensation case under special provision of 161 is quoted. So this next part is powers and jurisdiction of a motor accident claim tribunal. I said MACT. So this is MACT called in the short, and introduction only to be scheme of compulsory insurance under that. So powers and jurisdiction of motor accident claim tribunal, which is in short we called MACT. So when you go to the court, you will say, I'm here to file an MACT claim. You will not go and come back and say to the office, I'm here to motor accident claim tribunal, MACT. If you go to Pune court, in the Shivaji Nagar court, in the central building behind the Ashoka Hall, you have a MACT. It is available there. So motor accident claim tribunal is established to facilitate the speedy justice. It is a very special court which is created for specially for motor vehicle related compensations. What kind of compensations it will do? It will be have two types of compensations, right? First is where you can make a claim, the person is known, and you know exactly who is the person who has committed this accident, and then how the relief has to be sought through the insurance company of the person, or in case the person does not hold an insurance, which is again a penal crime, but then in case how to the compensation should be recovered from that person. While the other type is where the hit and run cases where you do not know exactly who has committed this offense. And then in that case, the central government monitored that fund. Solatium fund is used, and there is a performa to follow. There is a limitation period under which you have to do. And then there is a procedure which you have to follow, and the same procedure for the officers are also given. So that there are basically two kinds of awards. So power to award compensation is given to MACT. MACT has a power to award compensation. That is the primary role. So MACT are empowered to determine any compensation amount based on the evidence presented. So when you have to get any kind of relief from any kind of courts, what do? You do go ahead and you do a provide a evidences in support of your claim using both fault and no fault framework. So either you want to pick up a fault framework or no fault framework. It completely depends upon how you want to do it. Now, procedural fairness is something which has to be done by MACT. The tribunal process aims to be less formal. So, if you go to a civil court or similar such commercial courts, it is a very complex process. There are multi stages, very complex, very lengthy processes. But MACT, being a tribunal, it's a in between uh, the courts which are formal courts, and this is in between that, and the tribunal process is one step lesser and it's a less formal. It promotes a equitable access to justice. Equity is definitely part of the justice here also, because in this case the court will also see, the tribunal will also see, the both the parties are understood and heard, and the we talked about that the contributory aspect and the compensation, what percentage has to be reduced based upon your contribution also. So all those things are nothing but the equity based justice. Both the parties have equal access to the law. So equitable access to justice for accident victim to expedite the resolution of the claim. For example, a person submits a claim to the MACT. You go and submit a claim for the MACT for injuries sustained during any accident. So the tribunal evaluates the fact and determines appropriate compensation according to the law. If they need to understand something, some documents they want to bring in, they will ask for that. So an MACT makes a determination based on the structured formula also again, or set out in Motor Vehicle Act, ensuring fair outcome for all parties involved. So it will use the structured formula which we studied in 163A, which is part of the schedule, and they do a calculation depending upon what should be the calculation in case of a permanent disability or a death. So famous case law in this is Anjana Nair versus K. Rajesh. ANGANA Anjana Nair, NAIR Nair versus K. Rajesh, 2009. In this case, the court has come back and emphasize that the importance of MACT is very much to ensure that the accident victims receive compensation without undue delay. So in this matter, the court has come back and said the MACT has to ensure that it is very, very important that the compensation in any MACT tribunal is done without any delays and without much complex procedures and unnecessary delays, and highlights that the tribunal's role is to enhance access to the justice for injured parties, because in this case, the injuries are of the type where the person have immediate loss and the recovery, the cost is also immediate. If you have an accident now, you've broken a bone now, you cannot wait for 5 years when the judgment will come, then I'll get my bone fixed. It has to be done quickly. And even if you have, considered taking money from somewhere to use it or use your insurance, the other cost, everything is not covered. So the relief has to come immediate in such case of accidents. So that is why the court has come back and ruled that MACT has to ensure that it is not very cumbersome, it is not very delayed, and it is not very unnecessary complex. Other case law is National Insurance Company Limited. National Insurance Company Limited versus Pranay Sethi, Pranay, Pranay Sethi. So a National Insurance Company Limited versus Pranay Sethi. It's a matter of 2017. In this also, the court has not only talked about the MACT, how it has to work swiftly and in a very simplified manner. It also, the ruling says that to the extent of the powers of MACT to the decide on merits of claim and the criteria for calculating compensation, reinforcing that the effectiveness of the tribunal system has to be very clearly defined, and on the merits of the claim, the given structured formulas and the compensation calculation formulas has to be quickly used, whether it is a matter of a uh, uh, with fault claim or no fault claim, or it's a matter of a situation where there is a hit and run which has happened and the person is not identified. So in either cases, the MACT is a body which is a specific body, especially to take care of the motor vehicle accidents, and this is has power to award compensation. The very good thing is this is procedurally which is very simplified, and the timeliness also versus MACT is supposed to be very fast, and various judgments have been given. Two case laws I mentioned, where the courts has not only talk about the reason why the such MACT has to be very swift and has to be not cumbersome, complex, but also they should also be very much giving the judgments based upon the merits of the claim using the calculations which are given there. So the convenience of the Motor Vehicle Act is also given there, which is also time to time updated by schedule. Because see, if the schedule will come back with a breakup of the compensation components which has to be used and to ensure for to be used for calculating the compensation, it has to be revised also over time, because with time the types of vehicle, the types of accidents will change, and the prices of the those criteria will also change. What is the compensation value changes with the changing times also. When something, people used to have a salary of when 500 rupees, 200 rupees, the compensation was 10 rupees. Now, when the people have salaries and the cost of living going spirally up in the lakhs now, the compensation cannot be at the same. So that is why this schedule also keeps changing, and the MACT is somebody is a tribunal which is in sync with that to ensure the calculation is always up to the mark as per the central government schedules and the price list given. So let's talk about the introduction to the scheme of compulsory insurance under the Motor Vehicle Act. So Motor Vehicle Act, there is a compulsory motor insurance which is made, which I mentioned some time back when we started this session today. So the Motor Vehicle Act mandates now certain insurance provisions to ensure that all motor vehicles on Indian roads are insured to cover liabilities arising from road accident. Because if there is a compensation which is guaranteed, even if in the no fault liability cases, the other side, if there is no insurance, it is very much difficult to provide the relief. For example, if A comes out and the A is driving a vehicle, A has got no insurance on the vehicle, but A is a very good fellow. A goes and hits B on the crossroads. B gets injured. A stops there. A helps B. He's a very good Samaritan. He's a good person. But what is the problem with A is he has got no money in his accounts. So even if he wants to go ahead and pay, what is the intention going to help here? Or even if he has a coercive intention of not helping also, then also he would not let to part with his money. So either way, the person, if everybody is bound to go to the insurance companies and insure themselves, the insurance companies participating will have huge corpus, and the amount of accidents which happen is nowhere as compared to the corpus what the insurance companies receive. So it's a win-win situation for everyone. The person who has to pay has not to pay. The person who has to receive money will receive money. The person who has to pay on behalf of the person insured is the insurance company, has no problem, because the percentage of people who pay annually for that amount is very limited as compared to the number of the number of accidents which happen is limited as compared to the people paying. It's hardly the number of the amount of money which they have to pay is less. So that is why, considering all this logic, it makes sense to have a compulsory insurance provision which is good for everyone. So section 230, defines the terms associated with the motor vehicle insurance, ensuring clarity in the interpretation of the policy complexities. So let's read the wordings of section 230 first. So this is something which talks about, basically under section 230, it talks about the insurance which has to be done. I will omit this because it's a simple definition only. And 145B talks about the focus on the requirement for third party insurance, which protects the third party individuals against losses or injuries arising for vehicles. So third party insurance is what? Where the other part of the insurance is taking care of your losses. Your car is getting repaired under that particular component of the insurance, while the third party is taking care of somebody else. So if B has got injury under the vehicle of A, so the insurance, the third party component. So when you pay the insurance, there are multiple components you see while you pay. And there is some component which goes to the corpus of the third party, which company accumulates for each and every individual using that insurance policy across India. So third party insurance will now can be claimed by the other person who is injured. And then your insurance company will pay that third person that particular component, which is going to help him to pay his cost meeting with the accident. So the section says, no person shall use. So no person shall use except as a passenger or cause or allow any other person to use a motor vehicle in a public place. So no person shall use except a passenger or cause and allow any other person to use a motor vehicle in a public place unless there is in force in relation to the use of the vehicle by that person or that other person, as the case may be, a policy of insurance complying with the requirements of this chapter. Provided that in the case of a vehicle carrying or meant to carry dangerous or hazardous good, there shall also be a policy of insurance when under the Public Liability Insurance Act also. So that also has to be there. So yeah, so this is not 2023, it is 2019 they have started. So this was necessity for the insurance against a third party risk, which is mandatory. So no person shall use except a passenger to ensure that the vehicle when on street has definitely got an insurance policy. So a person driving merely as a paid employee, while there is in force in relation to the use of the vehicle, no such policy as is required by this subsection shall not be deemed to act in contravention of the subsection unless he knows or has reason to believe that there is no such policy or force. So it should not apply to any vehicle owned by the central government or a state government and used for government purpose, uh, unconnected with any commercial purpose. This is not required for any government vehicle. Why? Because the compensation can be paid by that particular department of the government through the Central Insurance Council. And the appropriate government may made order exempt from the operation of such section of any vehicle owned by any of the authorities of the central or the state government or any local authority or any state transport undertaking. So then that is what the explanation is. For the purpose of this subsection, a person driving a motor vehicle merely as a paid employee, while there is in relation to the use of that vehicle, no such policy is enforced is required by the subsection shall not be deemed to act in contravention. The person who is driving and who is a paid employee and has no reason to believe that there is no policy which is existing. He believes there is a policy. And then he drives, he is not doing any crime in this particular section. The crime is on the owner of the vehicle. So if tomorrow your driver is caught checking where the car is not having a valid insurance anymore, so the driver is not somebody who will be punished in under this law. The owner will be punished because he is just merely an employee who is driving it. So he's out of this, and plus the government agencies are out of it. They don't have a liability under this. While the section 147 talks about the requirement of policies in limits of liability. So how the requirement of the policies are in the limits of liabilities. For in order to comply with the requirements of this chapter, a policy of insurance must be a policy which, so how a policy has to be, is issued by a person who is an authorized insurer. So insurance policy which is issued is also by an authorized insurer. Not anybody can insure. So you need to have a proper insurance agent who is doing it. So either is an individual or a company, hmm, or any holding company. B, insures the person or the class of persons specified in the policy to the extent specified in subsection 2. So coming at subsection 2, we'll know up to what extent the insurance has to be there. So number one, B1. So section 147 B1, against any liability which may be incurred by him in respect of the death or bodily injuries to any person, including owner of the goods or his authorized representative, carried in the motor vehicle, or damage to any property or a third party caused by arising out of the use of the motor vehicle in a public place. Why this insurance policy has to be there? Because it will be against any liability. So whatever liability is being created against, what liabilities have been created? As any liability which may be created by with respect to death. So if any death creates any liability or any bodily injury which creates a liability to any person, including the owner of the goods of his or his authorized representative. So anybody who is the owner of the goods or his authorized representative, etc., carried in the motor vehicle, who is carried in the motor vehicle, or damage to any property, so which is inside the vehicle or outside the vehicle also, if any third party is also getting some kind of injury, all of these vehicle when running in the public place, whatever is caused is covered by under this policy. Number two, against the death or bodily injury to any passenger of a transport vehicle. So if any vehicle which is a transport vehicle in which the passenger, buses, etc. So any bodily injury or any passenger of a transport vehicle, if death also happens, except gratuitous passengers of a good vehicle caused by or arising out of the use of motor vehicle in a public place. Explanation: for the removal of doubts, it is hereby clarified that the death or bodily injury to any person or damage to any property of a third party shall be deemed to have been caused by or to have arisen out of the use of the vehicle in a public place, notwithstanding that the person who is dead or injured or the property which is damaged was not in a public place at the time of the accident, if the act or omission which led to the accident occurred in a public place. So it does not matter that notwithstanding that a person who is dead or injured or the property which is damaged was not in a public place. So, so that is something which is irrelevant. So now section 2, which talks about the, it was mentioned that up to what extent the policy we will help you. So notwithstanding anything contained under any other law for the time being in force for the purpose of third party insurance related to either death of a person or grievous hurt to a person, the central government shall prescribe a base premium and liability of an insurer in relation to such premium for an insurance policy under the subsection 1 in consultation with the insurance regulatory IRDA, Insurance Regulatory and Development Authority. So, one more point was there in the liability part 2, that the death or bodily injury to any passenger of a transport vehicle, except gratuitous gratuitous passengers of a good vehicle. So, person who is not paid any ticket, they not bought any ticket, and they are traveling free only because of some kind of help from the traveler or some kindness from the travel agency or the motor vehicle, the public transport vehicle. Those people are not considered under claim. So traveling without ticket, the person is not considered insured under this section as a third party as well. Now, policy shall be of no effect for the purpose of this chapter unless and until there is issued by a insurer in favor of the person by whom the policy is effected. So the owner of the vehicle and the policy owner has to be same. Otherwise, the insurance has no value. So it cannot happen that the vehicle is of A and the policy is of B. A certificate of insurance in the prescribed form and containing the prescribed particulars of any condition subject to which the policy is issued and of any other prescribed matters and different forms particulars matters may be prescribed. Now every particular of the insurance is defined and written in that policy, which has to be supplied together with the certificate of the policy. And why IRDA is something which is very, very important here as per the part of section subsection 2 is that all the rules and regulations have to be standardized. So it cannot be arbitrary by all the insurance companies. To make it uniform, then you have this IRDA, which is Insurance Regulatory and Development Authority. So they develop the new policies and they regulate the insurance policies shown, which is raised by multiple other companies. Now, where a cover note issued, sorry, notwithstanding anything contained in this act, a policy of insurance issued before the commencement of the Motor Vehicle Act 2019 shall be continue on the existing terms under the contract, and the provision of this act shall apply as if this act has not been amended by the said act. Of course, understandable. While number 5, where a cover note issued by the insurer under the provisions of this chapter or the rules of the regulations made thereunder is not followed by a policy of insurance within the specified time, the insurance shall, within 7 days of expiry of the period of the validity of the cover note, notify the fact in the registering authority or to such authority as the state government may prescribe. So if there is a cover note which is issued by the insurer under this particular provision of this chapter, or the rules which are given, or the regulations which is made under is not followed by the policy of the insurance within the specified time, then the insurance shall within 7 days expire. Notwithstanding anything contained in any other law for the time being in force, an insurer issuing a policy of insurance under this section shall be liable to indemnify the person or classes of persons specified in the policy in respect of any liability which the policy purpose to cover. So anyways, this is the mere basic thing that definitely there is an indemnity created where the insurer will ensure that the said indemnities are fulfilled by the insurance company. But what is the validity of the policies of insurance issued in reciprocating countries? So there might be countries where the insurance companies might be reciprocated. There will work here will work there. So where in pursuance of an arrangement between India and any such reciprocating country, the motor vehicle registration in the reciprocating country operates on any route or within any areas common to the two countries, and there is in force and relation to the use of the vehicle in the reciprocating country, a policy or insurance complying with the requirement of the law of insurance for the time being in force in that country, then notwithstanding anything contained in this section or subject to any rule made under 164B, which we spoke earlier, such policy of the insurance shall be effective throughout the route or area in respect of which the arrangement has been made, as if the policy of insurance had complied with the requirement of this chapter. Now, 149 section talks about the other aspect, which is settlement by the insurance company and procedure. So you have got the insurance which is coming from insurance company, which is regulated by the IRDA. You have the insurance issued by a proper insurer. You have the insurance which is indemnifying everybody the way it is promised in the wordings of the insurance policy. And it is something which is regulated to be mandatory by the government. So it has to be compulsory under this act. But then the insurance policies are meant for what? They're meant for settlement. So what is the procedure for the settlement? It is given in the section 149. So the insurance company shall, upon receiving information of the accident, either from the claimant or through the accident information report, or otherwise designate an officer to settle the claim relating to such accident. An officer designated by the insurance company for processing the settlement of claim of compensation may make an offer to the claimant for settlement before the claims tribunal, giving such details within 30 days and after following such procedure as may be prescribed by the central government. So if the claimant to whom the offer is made under subsection 2, where the offer is made, if the claimant to whom the offer is made is accept such offer, then the claim tribunal shall make a record of such settlement and such claim shall be deemed to be settled and consented. The payment shall be made by the insurance company within a maximum period of 30 days, the date of receipt of such record of settlement. If the person rejects such offer, a date of hearing shall be fixed by the claims tribunal to adjudicate such claim on merit. So basically, 149 is nothing but this is settlement by the insurance company. It's a duty of the insurer to satisfy the judgments and awards against persons insured in respect of the third party risk. So the third party risk has to be covered by the insurance company for the person who is insured, which means he has no financial liability to pay if the owner of the vehicle has a third party insurance covered through this insurance company, and it is a duty of the insurer to satisfy that judgment or award against the person. So whatever award will happen against that person has to be satisfied by the insurance company. So if after a certificate of insurance has been issued under the subsection 3 of section 147, we said the policy certificate will be issued with all the details and it is effected, then the judgment or award, whatever is in respect to such liability is required to be covered. It has to be covered by the policy and under the terms and condition and the variety of the policy, the ingredients of the policy, whatever up to the extent it covers, it has to be covered. Now, no sum shall be payable by an insurer under any subsection 1. So they are not supposed to pay any sum in respect of any judgment. So insurer is completely out of this once an insurance policy is purchased and he is not supposed to pay anything. If the person has avoided the policy, has not renewed the policy or cancelled the policy, then the insurer, person who is no more the insurance, has to pay in person. So then person is to pay everything in person from the whatever decree happens against him. In that case, the amount payable, the person cost, everything the person has to pay. But if not, if there is an insurance company has to pay. Now, the whatever sum has to be paid by the insurance company as per the judgment, whatever comes. And the award is given to the insurer, had notice through the court, and the court may send the notice to the insurer, but it has to be executed in effect by the insurance company. The claim tribunal of the bringing of the proceeding or in respect of such judgment award so long as execution is stayed thereupon pending an appeal, the insurer to whom notice of the bringing of any such proceeding is so given shall be entitled to be made a party thereto and to defend the action on any of the following ground. So what defense the person can take if in this case that there has been a breach of specified conditions of the policy. So this insurance company, they will come back with such clauses like a condition excluding the use of the vehicle. The vehicle was not supposed to be used here, and that's the reason I will not be paying. The person has to pay by himself, or the for hire or reward where the vehicle is on the date of the contract of the insurance of vehicle not covered by a permit to apply for hire or reward. So when the vehicle was under insurance, the person why the insurance company will not pay is basically, first of all, this is something which is a condition which is excluding the use of the vehicle. The vehicle was used when there was no permit to run the vehicle. Now, what is the permit? Permit is given depending upon the health of the vehicle, the possibilities of use of that vehicle for that purpose, and blah, blah, many other things, which means suitability to run the vehicle. If the suitability to run the vehicle was not given, even if you have an insurance, the insurance company will not pay, you have to pay because it is something where you have violated. It is a condition excluding the use of the vehicle. Or for organizing racing and speed testing. So if you're doing a racing or a speeding, if that is something which is causing, vehicles are not made for that. In normal conditions, vehicles are supposed to be run only on the street with the normal traffic conditions and the normal speed. So recently on this Pashan Road, two bikers midnight, they were racing. And this race, their super bikes, they were racing. They crashed midnight with the walls. They lost their life on the spot. One, other one lost while going to the hospital. Do you think the claims will be settled? No, there is no claim which will be settled because they have misused or they have not used as appropriately the vehicle. So they have contributed to the accident. If you are contributing to the accident, you are making it happen. Then why should I go back and pay you for that? I am there to help you in case if you run it properly. If you're not running it properly, how could I? If you start using your refrigerator to cook food, will a insurance company will come? The company will give you a warranty? No, they will not give you a warranty. So it has to be used for a specific purpose. Now, what could be the other reason for a purpose not allowed by the permit under which the vehicle is used by vehicle is transport vehicle. So if the vehicle is has to be used for certain articles to be transported, and the permit is only for using that. And say, for example, you have a vehicle, a truck, which you have permit to run across the nation to deliver any commercial object, any wheat grain, or any such food items, furnitures, or any construction material. And you ended up loading on that what? Firecracker materials, which is a special class of material. It's very dangerous material. And then you end up hitting a roadblock and you ignite the fire and your truck is gone, completely vanished in the vapor. So in those cases, it is not the permit which was given for the same purpose. So if the permit was not given, even if you're insured, insurance company is not liable to pay because it is excluding the use of the vehicle. Next thing is without sidecar being attached where the vehicle is a motorcycle. So that is if required, if there is a sidecar which has to be attached in a motorcycle, it has to be running with that. Or condition is a condition excluding driving by a named person or by any person who is not duly licensed. So if the vehicle is insured and it is being run by somebody who is not licensed, or by any person who has been disqualified for holding a license. In that case, if you're giving your vehicle in hands of such people, insurance company is not going to pay for you. Or a condition excluding a liability for injury caused or contributed to by conditions of war, civil war, riot, or civil commotion. If this is happening, insurance companies have no role to pay you because this is not the standard situation for which the insurance companies sell. That risk is not something which is covered for which they are charging you money. In such cases, if you lose your vehicle in the war, you have to steal some other vehicle of the enemy. There's no other option. Number B, that the policy is void on the ground that it was obtained by the non-disclosure of a material fact or by a representation of fact which was false in some material particular. So if it is found that some insurance details while filling the form were not right, then of course it is not which the company will respect. So any such judgment which comes, if all in this case is fine, then the insurance company will come and pay you. If either of them is or more than one is applicable, you will not get any insurance money. So these are things which are material fact, material particulars related, which has to be completely correct when you are filling a form for getting the certificate issued to you. And it has to be run by a person who is eligible to run and for all the reasons for which the vehicle has to be run and allowed to be. For example, if somebody drives a vehicle involved in an accident without a valid insurance, severe penalties as per the new law, because they have, first of all, not brought that procedure, that they have not brought that, followed that procedure of having a motor insurance, which is compulsory by law, which means this is again a crime which has done, and the injured parties may be unable to recover damages unless insured or you have to pay. A motorist who is say for example in accident must have insurance that covers a third party liability also. So there cannot be an insurance in India which can be issued which does not have a third party in case of a motor vehicle. Otherwise, there is a legal repercussion of those things. Now, famous case law is National Insurance Company Limited, National Insurance Company Limited versus BK Rathi Brothers, 2005. The court ruled that the insurance companies are liable to pay compensation to victim as long as the vehicle was covered under valid insurance policy. So a recent judgment which has come last month also, for a situation where the vehicle company, the insurance company has rejected a claim saying the insurance was taken in the city of Pune. It was obtained in the city of Pune, while the accident has happened in the city of Ahmedabad. So the issuance of the insurance is in one city, while the vehicle was used in some other. It was a private vehicle, non-commercial. So we do not respect the claim because it is not obtained in the city where it is running, where the courts have ruled up to the highest level of the court in India, the Supreme Court, that it is immaterial. What is important is the proper policy has to be obtained for this purpose for the from the right insurance companies, has to be obtained by the right insurers, has to be obtained the certificate with the right particulars, and then has to be run for the right reasons by the right people. That's all. Otherwise, there is no point of rejection by the insurance companies which can happen. So after the 19 2000 sorry, after 2019, it is mandatory to have the insurance policy before you ply the vehicle on the street, and it is your legal responsibility, legal liability as well, to ensure you are definitely having one while you drive the vehicle on the streets. And with this, we come to module 8. Remedies in tort law. This will be quick and fast because we have gone through a lot of things. A lot of things are repeating in tort. And then we'll do after that chapter 9, which will complete your whole syllabus of consumer protection law. I might go a bit little further than 10 o'clock today. Hope this is okay with all of both of you. So remedies in the tort law. We have seen a lot of that while we have studied in last couple of days. And we'll just try to understand again the judicial and extrajudicial remedies which are available in the tort law. So the judicial remedies are given from A, B, C, D. So the very first is damages. So what is a damage? Damage is a monetary compensation, which is awarded to a claimant to restore them to the position they were in before the tort has occurred. So the principle of the tort law is to compensate the injured party rather than the punish the wrongdoer. And that is why the damages we look in tort from the perspective of compensation to bring me back to the position where I was there before this tortious activity has happened. So what are the types of damages? General and special, nominal, contemptuous, aggravated, exemplary. So let's see one by one. So general damages are which are compensated for non-monetary issues. For example, pain, suffering. A victim of defamation may receive general damage. Are you going to put a piece of brain in his mind, or you put a bigger heart in his chest? Nothing, right? So a victim of the defamation will recover. You cannot inject something, some component you cannot put. It's a damage which is mental. It's a respect related thing. So a victim of defamation may receive a general damage for emotional distress without needing to prove actual financial loss. A person injured in a car accident may claim general damage for long-term pain and suffering resulting from that injury. So a general damage will be there, which is the most common damage, where you can straight away identify it as a damage which has happened to your mind or to your body. But mostly it is for non-monetary losses, for example, pain, suffering, etc. And it's mostly which is uh, which can be compensated by the general damages provision. So in case of a defamation, we said it's a non-monetary loss where a respect has gone. It's an emotional distress. In case of an injury for the sake of pain and suffering, what you are gone through, it's a non-form of financial loss. But then you can ask compensation for. In both the cases, these are non-financial losses, but you are able to get a compensation for non-financial losses also, like pain, suffering, mental trauma, etc., etc. So this is general damage. Key identification is this is compensation for non-monetary losses. Then comes the special damages. So special damages are compensated for uh, quantifiable monetary losses. For example, medical expense. Hmm. So general is where non-financial, why special is for quantifiable monetary losses, medical expenses. A person recovering property damage, they can ask a cost for a negligence claim due to a fallen tree by the neighbor from the neighbor side, and they can ask for a compensation quantifiable monetary. Okay, this much amount I need to fix the wall. Everybody can do a calculation and they can find. Or a business specially damaged for the lost profit after being wrongfully accused of a crime leading to a shutdown. They can come back and say, this much I was earning last year, I want that much of money to sustain back. These are my losses. So these are quantifiable damages, which you can, or probably somebody is getting something repaired in their house, and they go ahead and make a damage to your mirror or the window glasses. It's a quantifiable loss. So it's a special damage. So this is difference between general and special damage. One is for non-monetary losses, one is for quantifiable monetary losses, just opposite to each other. Now come to nominal and contemptuous damages. So nominal damages are small, as the name says nominal. It's a small amount awarded. So these are various scales. Huh? So types of damages, when we talk about general and special, this is from perspective of what? Is it quantifiable by money or not? The damage. Is it something non-monetary loss or monetary loss? Now, when we come to nominal and contemptuous damage, it says small amount awarded with a legal right is when a legal right is violated, but no substantial losses happen. So small amount has to be awarded, and when a legal right is violated. For example, a nominal sum of $1 is awarded in case where a tortious act happened but did not result in a physical or economic harm. So a very famous case of one very senior advocate in the Supreme Court, where a contempt against him was brought in, and that's where uh, he was fined with a very nominal amount, which was rupee 1. So nominal damages. For example, two, a trespass can happen where the landowner claims only a negligible inconvenience due to a defendant's minor encroachment. If they've done a small encroachment for some time, it's not a very big thing, but it's a something where the right has been devoid, it has been taken away. While the contemptuous damages is awarded to indicate that the claim was not worthy of serious consideration. It is not even worthy of a serious consideration. For example, a court award a minimal amount to a plaintiff where the case shows a clear lack of merit, such as spurious lawsuits. So there is something where there is nothing to prove, but somebody has put an allegation. So these are contemptuous damages. For example, a claim for harassment where the evidence does not substantiate a significant invasion of the right. So nobody has any substantial right where there is an evidence to show there was a significant invasion of that particular respect or right. So these kind of small things are contemptuous right, while the nominal is actually something which is nominal, but it is something which is a legal right which is identified. It is easy to identify, but in terms of contemptuous damages, the awards are given to indicate that the claim was not worthy of serious consideration and very small amount could be still given in spite of having no clear indication about what is the quantum of the damage which has happened, or even it has happened or not. Now, aggravated and exemplary damages. So, aggravated and exemplary damages. The first one is, let's say talk about aggravated first. So, compensation for additional harm which is caused by the defendant's action. For example, malicious or oppressive behavior. An assault happens where the defendant's action caused not only physical but also emotional trauma to the person, leading to higher compensation package. So he has given him so much of cuss words and so much of dirty words. He has gone in front of the public. He has given a lot of things. What he has said has caused him emotional breakdown also, emotional trauma also. That is where it's an aggravated damage. So damage was there, it is aggravated by additional things. Where in this case, when the example is given, is for abusing the person through words also, or a case of discrimination, where the treated person who is discriminated suffered humiliation. He is humiliated and distressed beyond the ordinary effect of the tort. So while disrespect was done, additionally, a discrimination was also being done and openly to him. So this is called aggravating the person's position while he was under a tortious situation, where he was brought under tortious situation where tort has happened against him and a compensation is sought. But it was seeked for an assault which has happened. My injury is my cost, but it is aggravated because I'm mentally also hurt. While in the other way, when we talk about the exemplary damages, it is also known as a punitive damages. So the second name for exemplary damages, punitive damages. As the name says, award to punish the defendant and deter future wrongdoing. So these are punitive damages. So awards, we have seen in some previous chapters also that it is possible to give some small punitive award also to the defendant. For example, an award in case of a gross negligence resulting in death, where the court seeks to deter similar conduct in the industry and they ask for cancelling of the license. So, a doctor leaves a towel in the stomach. Will the court only give a tortious relief to the person and give him the compensatory relief for what? For getting him under the blade again to get the tools recovered out. All the pain and suffering, all the fear of being operated again, all the other mental and physical harassment, what the person is having. No, there is a punitive damage also which has happened. And for that, court will go ahead and also issue an order to permanently or for some time suspend or completely remove the license of that practitioner, or cases involving a some kind of flagrant disregard for safety regulations. So there is a safety regulation which is made, and somebody has completely disregarded that, resulting in a severe injury to the patrons. For example, Upahar Cinema case, which is a very old case in Delhi, where the fire has happened and people were baked and cooked inside the cinema hall. Hundreds of people were burnt alive in the cinema hall. So in that particular case, it was not only the matter where exactly the tort has happened to the people who have got injured. Let's talk about the injured people. They can come and claim tort. No, the cinema theater also has to be punished and fined for the negligence they have brought in, plus their license also has to be suspended forever. Or in such cases, multiple other, for example, somebody who's running an amusement ride, they have not done the checking of the machines, which is required by the law. They have not put in the right certificates. They have not put the maintenance of the machine right. In that case, if somebody is getting injured, it is not only the tortious liability comes out for the financial loss. It is the machines have to be stopped. Also, the amusement park also has to be locked and shut down. So coming back, aggravated and exemplary are very distinct and very quite different. Aggravated is, as the name says, it got aggravated by some other elements, while exemplary are ones where there is a need for exemplary punishment of some kind of punitive punishment also has to be given to the defendant. So let's talk about the principle of uh, causation of the damages. So what are the causations of the damages which can happen is establishing a direct link between the tortious act and the damage incurred. We read about it in the previous chapter also, that causation is a link between what activity which has happened and it's a link between the tortious act which has happened because of that. I jump the signal, I make a tortious act, and I go ahead and hit somebody. And between that, this is the causation which is the link. So this has become a causation to happen, the tort which is the final result for which the compensations may arise. Foreseeability. We have read about it also in the previous chapters, where it is a damage must be foreseeable. It's a responsibility of the person and act accordingly. I should have foreseen that I shouldn't have broken the signal and I shouldn't have jumped. So that is, the defendant should have reasonably anticipated the harm resulting from my action. Certainty. So the damages must be quantifiable with reasonable certainty. Vague estimates or speculative loss generally are not compensable. So nobody will compensate those kind of losses. Now, so these are the principles basically for the calculation of the damages. And there are personal injuries also which happen. For example, in the damages, there is something called personal injuries, where includes both physical and psychological injuries. We have seen a lot of examples until this point when we have reached in this chapter. We have seen a lot of examples where physical and psychological injuries both can happen. Both are personal injuries, which is considered under tort. And damages are often calculated based on both. We just saw that, right? That medical cost and the impact of injury on the daily life can also be calculated. Or in the aggravated damages, we can ask for the actual damage which has happened. My bones are broken. I need a medical attention. I have the cost, but I have also disrespected so bad that I am my I'm humiliated, I'm mentally broken. So that also could be tried to be quantified and an amount can be put around. Or probably an injury has happened, a tortious activity has happened, my operation has been not done properly. I'm again absent in my office, my salaries are being deducted. That is also something which is which could be compensated. Now, death can also happen because of damages, like claims may include loss of consortium and funeral expenses when a wrongful death occurs. So if a wrongful death occurs, for the death, the any ritual related cost or any kind of uh, transport of the dead body is also covered under the damages of death. And loss of property is calculation based on the repair or replacement. So in both the components are taken. So because a loss of property can have either you repair it, that cost, or you replace some things you cannot repair. And then economic and non-economic losses also happen, which is quite clear, is both tangible and intangible. For example, any article lost, any document lost, any cost is a tangible cost, any lost wages. While intangible, we have seen the humiliation, the pain, the suffering. So these are also kind of losses which can happen, economic and non-economic losses. Point B under Module 8 ACE Chapter 1, point B is injunction, permanent and temporary, co-timate action. So it is a in court order that restrains a party from taking specific actions, prohibitory injunctions, or compels them to take action, which is mandatory injunction. The purpose of injunction is to prevent harm or maintain the status quo while a legal matter is adjudicated. So it could be temporary also, it could be permanent also. So injunction is something which is uh, it's a restraint which is created. For example, if there is a property which is in question where the legal battle is going on in that property, if there is a chance the other party might go ahead and he might go inside, destroy something, he can cause a theft, he can cause a damage to the property, and both the parties have their own separate abode where they can still stay, live, and live happily. Either of the parties can put a request for interim relief, an injunction, saying until the matter is going on, the matter is being adjudicated, though nobody goes and enters that property. Or you go ahead and compel them to take certain action. For example, if you're injured and by the time the matter is going on, there is a continuous loss to you, for example, in a matrimonial situation, in those cases, you will ask a certain amount to be paid on regular basis so that you are able to sustain, the other party is not at loss, or a situation of a permanent damage does not happen to the other party, which is irreparable. Or, for example, there is a property matter going on, and uh, we are it's a big property, residential property, and I have been outcasted from the family to some. I don't have a money and place to stay, so I can compel them to take an action that I have given a separate exit and I am placed in a separate floor in the building until and unless it is adjudicated and decided who stays, who does not stays, etc., etc. So the purpose of the injection is to prevent harm or maintain the status quo. So in those cases, either I prevented a harm where I might have suffered without the money or without a boarding, or maintain the status quo where I have kept the property preserved until the matter is going on. So types of injection by default definitely could be temporary or permanent. So in case of temporary injunction, it is issued to maintain the status quo pending a final judgment. Until the judgment under the matter is in run, the temporary injunction will go on, or probably up to certain point of time. So generally, these are sought to prevent irreparable harm before a full hearing or the merits happens. For example, let's take an example where a property owner seeks to prevent a neighbor from building building a fence. He's building a fence, and they have a dispute that where the fence has to put. So he seeks a prevent a neighbor to build a fence that would block their view. So the court may grant a temporary injunction while the dispute is resolved, saying until the dispute is not resolved, you will not put the fence. Or maybe a company can come and seek us temporary injunction to prove that a former employee from has disclosed the trade secret, has sold the company documents outside, but they can put a temporary injunction to ensure that that employee is not thrown out until this decision is made. Because until it is not proved, we don't know if he has really done that. But if you don't do that, if a temporary injunction is not brought on behalf of the employee, he might not get a job easily and he might suffer. While the permanent injunctions are issued as part of a final judgment. So the temporary judgment has injunctions have come where it has come as a remedy before the final judgment. For the time being, it is something which is put to ensure you get a relief to maintain the status quo or preserve something until a final judgment is made this side or that side. While the permanent injunction is a result of the final judgment. So it commands the defendant to do or to refrain from doing a specific act permanently. So that is a permanent injunction. So, for example, a permanent injunction could be put to stop a business from polluting a river after finding that it is causing lasting environment in the damage of the policy. The fishes and the flora and the fauna are getting damaged. So after the particular judgment, they will say you stop operating in that area. You shift somewhere else, or you put certain kind of filter, certain kind of recognized steps to clean the water when it goes to the river before that. Or, for example, a trademark infringement case I mentioned last time. So the court might grant a permanent injunction to prevent one party from using one trademark. Now, the say is co-terminate action. So this is co-terminate injection is a type of injection which is sought to prevent a future harm or threat even before any actual harm has occurred. It is based on a reasonable fear of impending injury and it's a precautionary. For example, an artist might seek a quit terminate injection if they believe a competitor plans to release a similar work that would infringe on their copyrights. So he can put a this particular QR timed injection. Or for example, a homeowner may seek this type of injection against a neighbor's planned construction that could encroach upon their property. The neighbor has started to build a new house and he knows with the blueprint that it is something which is going to encroach their property or block their property illegally or causing them some kind of discomfort. In that case, such kind of injection could be sought, and until that point of time, the final judgment comes, this kind of injections could be in force. So, for example, let's take the case law. American Cyanamid, American Cyanamid, Cyanamid, Cyanamid Company versus Ethicon Limited, 1975. So, American Cyanamid Company, Cyanamid Company versus Ethicon, Ethicon, Ethicon Limited, 1975. In this landmark case, the House of Lords established the guidelines for granting interim injunctions, emphasizing that the need to consider the balance of convenience between the parties is very, very important. And if such a situation can arise where one of the parties or both the parties, say either of the parties or both the parties, might get impacted severely by the time the judgment is arrived, it is very, very important to bring a temporary injunction to ensure that the convenience of the parties is also taken care by the time the judgment is happening. Next one is Warner Brothers, WARNER, Warner Brothers versus RAP, RAPP, RAP. It's a 1980 matter. In this case, the court upheld a permanent injunction to prevent the unauthorized use of characters from Warner Brothers franchisee, reinforcing that the protection of intellectual property rights are taken care through the injunction. So it's a permanent injunction where they say you cannot use the authorized, you are not authorized to use the characters of so and so Warner and Brother uh, business, which was a permanent injunction. They were not allowed to do. So this is about injection, permanent and temporary injection and coartimate action. Now, Replevin. So it's not a medicine. It sounds like a medicine. So Replevin, the by definition, it is a legal remedy, which is allowing a party to recover position on specific goods that are wrongfully taken or retained by somebody else. So it's a Replevin. It is primarily aimed to at retrieving personal property rather than seeking monetary damages. So you don't want a money in lieu of whatever somebody else has wrongfully taken or restrained. You want that thing back. That is the replevin. So typically in this case, the of replevin, the party which is claiming replevin must demonstrate rightful ownership of the goods, which is but natural in question. And then they have to be also shown that although he is the rightful owner of the goods which are in custody of the other person is taken unlawfully or detained unlawfully. So both the points have to be proved that yes, this particular property is mine, but it doesn't prove anything beyond that. But it might happen that you might have a legal transfer to that person. So you have to prove that it cannot be or it is not a legal transfer also which has happened or a detention which has happened. For example, if a leasing company which does leases, so the leasing company leases a equipment to a contractor. It has given to a contractor on lease some equipments, and the contractor refuses to return it after the lease. So the leasing company can pursue replevin to recover the equipment, and they can easily show that this is they are the rightful owner by because the purchase slip would be have been with them, and the unlawful seizure because the leasing contract itself would show that this particular machine with serial number so and so belongs to him, and it is only has to be given for certain time period, and it is beyond that, it simply means it is an unlawful presence of the particular thing in the premises of the defendant. Or, for example, a person who has their vehicle wrongfully repossessed may file for a replevin to regain possession of that vehicle while disputing the legality of the repossession. So, for example, somebody has taken a loan from somebody, and then the person actually has paid all the EMIs. The company comes and takes away the possession of the car. So then, in that case, it's a replevin. Or you have bought a car from, so Varad has bought a car from Riddhi, and he has made all the payment, which is proved. Still, she comes in the evening, picks up the car, and takes her to her campus and parks there. Replevin is your recourse, Varad. So uh, now let's talk about ejectment. So, as the name says, it's a legal action to reclaim possession of a property from a party that is wrongfully occupying it, and this remedy is common in landlord-tenant dispute and property dispute among individuals. It says ejectment. Eject means to go out. You eject the CD from the CD player. So ejection is coming out. So ejectment is a legal action used to reclaim possession. I have a property where somebody is going there and sitting there, and they are not coming out of that. And through the legal remedy of ejectment, I eject the premises from them, and they're all moved out of the property, and I recover the possession, reclaim the possession of the property from the adverse possession what they are having. So what is the application of ejectment? It is the plaintiff of the party, which is the party seeking the ejectment, must demonstrate they have a legal right. First of all, in the court of law, when you go, the court doesn't recognize 100% all the citizens of India or to the neighboring part. So you have to go back and make a point, first of all, that I'm talking about ejectment of so-and-so property, then this property belongs to me. I have a legal right to be having the possession of the property, and then the defendant is an unlawful. Same way as we have done in Replevin. That is for an article which is in possession. This is a property which is in possession. So, for example, a landlord seeking to remove a tenant who has failed to come pay the rent may file an ejectment suit and again get a possession of the rental property. It's a flat or it's a shop, doesn't matter. Or probably the rent agreement has finished long back. The tenant is not moving out, not paying anything. Then ejectment is an option. Or in a dispute over property where boundaries, a landowner may file ejectment against a neighbor where he has encroached their land without permission. So he has encroached some part and he's put some of his articles, has put some of his construction there, temporary construction. Some cows he has brought in and he has tied in his campus. Some dogs, some chicken, some eggs. So he can go for an ejectment suit and everything will be thrown out of his campus legally. It will be ejected out of the office premises. So very famous case law is Higgins versus HQC. Higgins, Higgins versus HQC, all in caps. So Higgins versus HQC, matter of 2008. The case highlighted the right of landlords to evict tenants for non-payment while laying out the necessary legal procedure that must be followed during the ejectment process. So you can eject somebody, but it's not that the moment you get a court order, you can just go ahead and you can throw the tenant out of the house immediately. There is a process of doing that. So for ejectment also, there is a due process which has to be followed. The court will give certain timeline to the person to go out of the premises. There might be some kind of assistance from the police which is seeked, or some other persons, private persons also, who is a court receiver. Or it is quite a possibility that there is a particular procedure or timeline of partially coming out and fully coming out. Because what when we talk about ejectment of a tenant and the property, what comes to our mind immediately is what is the flats, how we rent and we stay in that as a tenant. No, that is not only the tenant and lease agreement, tenant and the owner relation. It might be a big factory also, where the person is not leaving the rented premises where he's manufacturing, but it is practically impossible for him to go out of the factory within a month or two. It might take 6 months also. The court might come back and say, okay, you're ejected out of the property in 6 months' time, while you take out, step by step your machineries and put it somewhere else and keep connecting, installing it there. How you uninstall from here, you install stepwise there also the other side, so that you are operational after 6 months. By the time you pay so and so fee and so and so penalty also every month. So it should have a necessary legal procedure also which has to be brought in while the ejectment is happening. That is what was decided in the Higgins versus HQC. Now you come to another case law which is Doe D. Smith. DOE, Doe is one word, D is one word, and Smith. Doe D. Smith versus Mac Guinness. MC Guinness, GINNISS. So DOE D Smith versus Mac MC Guinness, GINNISS, Guinness, 1831. So it's a pivotal case which illustrated that the enforcement of right in ejectment claims that emphasize the importance of showing legal entitlement to the property in ejectment proceedings. It shows that it is very, very important that the legal entitlement has to be shown, because these were the days when these processes were starting and shaping up. So that is why it is something which is very, very important. Okay. Then we came to the extrajudicial remedies. So there are extrajudicial remedies like self-defense. So if some tort has happened, that tort has happened because of my self-defense. We have studied about it in last session also. So no need to go back to that again, because if in self-defense you have done something which has caused into a tort, it is not considered a tort if it is proved that way. Re-entry on a land. So if you are able to prove that it is not a tort we have created, but you were actually somebody who was owning that particular land and you have just re-entered the land, while the plaintiff himself is actually somebody who has somebody who has entered the premises. So it is just a re-entry on the land, or you have no other provision to enter your land and you have to go through that land and you are re-entering to that land. In those cases, the defense of re-entry on the land can be taken. Recapture of the good is where you have to go back and prove that this is an extrajudicial remedy where the capture of the goods is been done by you. It is not who has encroached the materials, but it is somebody who is recapturing the goods for yourself. Abatement and distress damage feasant is also something which is of similar type, where abatement is somewhere where some legal rules have been violated, and that has caused this situation. It is not a tort from your side, that is an abatement. And distress damage feasant is also the very same way, where because of a distress situation, this damage has happened. I'll and that is why this is not something which is uh, done by you. And once again, message I'm getting. Okay, so this is something which is the extrajudicial remedies which we have already studied in multiple times. So, for example, let's take an example of distress damage feasant where, uh, for example, a landowner, he has to seize and he has to detain another's property, cattle or other kind of chattels that is wrongfully on their land and causing damage. So it is a distress which is caused by his property, and to conclude, come out of that particular damage, you have, uh, you know, uh, caught hold of his cattle, and until the compensation is not met, you are keeping that with yourself. So this is because of a distress damage which has caused the particular uh, tortious activity which the plaintiff is claiming has happened. So this is about module 8, which talked about the damages, the injunctions, the replevin, the ejectment, etc. Let's move to the last chapter, which is consumer protection law. So what I would go through is first chapter 1, which is origin and development of consumer law. So consumer protection law in India is basically designed to promote and protect the rights of the consumer, and this will be discussed further. So historically, the consumer protection laws have evolved globally now, and in the India to address the growing complexities of consumer transaction and disputes, particularly with the advent of industrialization and globalization. Now, consumer rights over time in India has changed. When the Originally, when the consumer laws were brought in, the scope of the consumer law was uh, completely different as compared to what we have right now. So it had a very limited scope, not in the sake of remedy, but in the sake of how it was designed to also. So that is why the shape and picture of the consumer law in India has changed dramatically and a lot, because the types of tort which can happen, the types of issues which can happen in the consumer area has changed a lot. So although the consumer law is not something which is only part of the modern India, it is something which was also part of the historical India. Historically, also there are a lot of trade restrictions, there are a lot of regulations which were there, which were nothing but the part of the consumer law, where the penalties were there if somebody is not doing it properly. So uh, in the British time, it took a shape, a better structured shape, and the Consumer Protection Act, which was enabled in 1986 in India. It was passed in 1986, which is defined the word consumer properly. So in the 1986 Act, finally, we were able to define the basics of some of the Consumer Act, which is the consumer, which is somebody who defines a consumer as somebody who pays a money to buy a good or a service. The somebody who is directly involved to buy a good or a service. And then in the this act also, uh, the redressal mechanisms were brought in that point of time. So the redressal mechanism started with this particular act in a very structured way, 1986, and it also conferred the right. Various rights were conferred. Additional right to the, for example, the right to safety, the right to be informed, the right to choose, the right to be heard, the right to seek redressal, the right of consumer education, or even the right of repair now what we have. So all those things have evolved over time, because the right of repair is the latest one which was added, where the companies cannot come back and void the warranty or the guarantees if the service, if the gadget or the appliance is repaired in between at home or by some other third party vendor. If that attempt is made, there is no voidance of the guarantee in the warranty anymore in India. Then after that, after 1986, what came was the Consumer Act 2019. In the 2019 Act, replaced the 1986 Act. And then it introduced a stricter provision. It has brought more relief to the consumers by the changing time, and it has brought an online mechanism for dispute resolution. So 2019 Act, which brought in a relief to customers by sitting at their home through the online mechanism, also they can file a complaint. And the penalties for misleading advertisement was also brought up in 2019, where anything which is misleading could be penalized, further strengthening the consumer rights. It has further strengthened. So consumer movement in India started in early part of the 20th century with the formation of organizations like Passenger and Traffic Relief Association in Bombay in 1915, etc., etc. And then NDRC was also, after the 1986 Act, the National Consumer Dispute Redressal Commission, a proper commission to look into the rules and regulations and the mechanism to get the disputes redressed for the consumers, was also constituted in 1988 after that. So, this is a brief about the origin and development of the consumer law in India.
Yeah.
And initially, consumer rights were framed to counteract unfair trade practice only, which is fraud and exploitation. But it has gone up to those many rights which I just mentioned. Those things are additionally added over time. Now, some basic concepts which are brought from these laws are like consumer, which is an individual who purchases goods or services for personal use. That person is a consumer, which is defined. A complaint is defined as an allegation of a defect in a good or deficiency in a service, which is leading to the filing of a grievance. So any consumer grievance when it is filed. So why it is filed? Because to allege something about a defective product or a defective deficient service by somebody, and that is what is called as a complaint. And the person who is making the complaint is nobody but the complainant. A person who files a complaint is a complainant. Service and goods were also defined, where the goods are tangible. You can see that, you can touch that. So goods are tangible products, while the services all are intangible benefits which are provided as promised to the consumers. So whatever is promised and provided to the customer for their benefits, those intangible benefits are the services. If you get a service from some company, that service, if it is deficient, you don't see the service by your eyes. It is something which is done by, at the end result, something happens which helps you or doesn't help you. But in between, what happens is the service operation is something which is a which is something which is an intangible benefit of that particular process which you buy for yourself. So that service is an intangible point, and goods are tangible. Then there is definition of defects and deficiency. So a defect is something which is a flaw in the good. If there is a flaw in the good, that is a defective product. So that is a defect in the product, while deficiency means shortcoming in the services. So basically something which is absent, which should be there. For example, if I buy some kind of machine which has to do, say, a washing machine, and the washing machine is supposed to, as advertised, as the product is sold, is supposed to wash the cloth and then dry the cloth to the extent. When I start the machine, it washes the clothes, but it is not working to, the dryer is not working. So in that case, it's a defective machine. So it's a defect in the product. While deficiency in the service is, for example, you have gone to some kind of say some kind of restaurant, and you have some kind of services given to your people. You know, you have a big party you have organized there, and the hotel or the restaurant where you have organized this party, the services are so deficient that the guests are not served well, the foods are not served on time. The people who are asking for something are not served at all or missed. So this is some kind of service which is not working fine. So this is a deficiency which is happening in the service. So defect is in terms of tangible things, while deficiency is in terms, mostly in terms of the shortcoming in the services. So it is deficient service. Then trade is defined. Trader. So a person or entity that sells good or services is a trader. A trader could be a company like a biscuit selling company or a consumer good selling company, which is a trader, uh, is a local person who makes the biscuits at his home and sells on the street. He's an individual seller, or could be an entity like a Glaxo company or whatever company, Britannia company. So these people are entity. These are companies. While services could be given from a single person. For example, a single hairdresser gives a service of hair cutting, while it could be a famous Habib's chain also, which is an entity which is giving services. So that is a entity which sells a goods or services. So that is how the trader is defined. Then consumer dispute was a word which was brought in, which is a very big change in the landscape of the customer laws, where a dispute between a consumer and a trader regarding the quality, cost, or safety of a good, or many other such attributes which I mentioned at the start of the discussion. We're talking about the origin development of consumer law. So all those things, any dispute which is brought against the trader. So the consumer we have defined, the trader we have defined. So between the dispute between a consumer and a trader regarding the anything like quality, cost, or safety, or any such probably a wrong advertisement, a misleading advertisement, anything that could be considered as a consumer dispute. So that is something which is trialable in the those consumer protection laws. For example, recently I did mention, I think in previous class also, even an experience which is promised could be something which could be a dispute between a customer and a trader. I went to a shop which promises me a very good experience. We promise a very good experience to you, sir. You come to our shop. I go to the shop, things are done, but the experience is very bad, extremely bad. I can also sue and I can also raise a dispute against that trader for the bad experience. So that is also one attribute. So any dispute which is happening for relation of anything which is trialable under the and recognized under the consumer laws in India is called, or anywhere in the world is called, the consumer dispute. And that is how the consumer dispute is empirically defined. Let's talk about a restrictive trade practice or unfair trade practice, both of them. So restrictive trade practice and unfair trade practice, practices that negatively affect customer, such as false advertising and fraudulent business actions. So if a restrictive trade practice is there where it is a ban, it is not allowed to do that kind of services. You're not allowed to sell that kind of products, and which is a or you are not supposed to practice such kind of things while doing your business, then it is a restrictive trade practice. Okay. If I have go back and I have to do an unfair trade practice, so then that is something which is also impacting me. For example, a false advertising is an unfair trade practice where I come and advertise something else and I give it to you something completely different, the service or a product. So this is an unfair trade practice, or any fraudulent business action is covered under restrictive and the unfair trade practices. Now, the authorities are defined under this act are the consumer councils, which are the bodies which are established to promote and protect customer interest and provide guidance. So these councils to mostly to provide and promote the consumer interest and provide guidance. So they do advertising, they go ahead and frame new rules, they go ahead and protect the customer interest by educating them, and they provide the guidance if approached. Then there are redressal agencies, the agencies which are under this law authorized to do redressal. For example, the district consumer dispute redressal forum, where you handle the complaints at a district level. So, in district level, and please understand, these are also limited to the amount of, the good, the price of the good, sorry, which is up to what level you can go up to what level of redressal forum. Then there is a state consumer dispute redressal forum, which deals with the appeals from the district level. So whatever district level appeal is coming, so you have to, even if you go online on the consumer redressal forum website, you have an area to file consumer forum disputes on the district forum, but also you have a appeal section where you have to mention the very first thing is the case number from the previous complaint, is it district or state level, where you have to go and mention that. So various districts will have uh, the various level of cost of the article or the service, which is also something which is a scale on which they can try that particular redressal. Then the last one is a National Consumer Dispute Redressal Commission. So this is an apex body for the handling consumer disputes at the national level. So there is a provision at appeal uh, for the consumers at the various different level. So they are available at the various level, and they are also divided on in terms of what are the various levels they could try with. Okay. Now there is a composition of the composition and the jurisdiction. So each forum, either a district forum or a state forum or a national consumer dispute redressal commission, each forum and commission has a specific composition requirement, a territorial jurisdiction, and what is the power to educate based on the value of the dispute. So a certain value of the dispute is which drives the jurisdiction also. So uh, either it could be appellate body or it could be driven by the value of the disputes. There are remedies which are available under this act. Are what are the remedies? You can get a compensation for anything monetary. You can get a refund. You want to return the things, you want to get your money back. You can get an order for removal of defect. So the agency will come back, redressal agency will come back, and they will ask for removal of a defect also, and corrective advertisement. They can come back and say you retrieve this advertisement and you bring the right one, which talks about the right thing, or you give certain things that smoking is injurious to health, blah blah blah. So whatever it is, so corrective advertisement has to be put. So all of these and many other remedies are available. These are one of the few which we are mentioning. Many other remedies are available, depending upon all the various rights which are protected. The various kind of remedies are generated, and then procedure of basically filing a complaint is the filed complaint with the either you can go physically or you can file it online also. There is a limitation period like any other court matter where you have to go and check on the redressal forum what is the limitation period for your particular matter. And then once it is done, when the redressal is done, there is a mechanism to enforce the orders also, and which is ensured, which is released to the various parties, and ensuring the compliances are done. And there are vexatious complaints also, which are something which is very important, where a provision to discourage any frivolous complaint is automatically a mechanism which is initiated at the very first stage when the inquiry of that particular matter which is filed, which happens to, so that the unnecessary vexatious complaints are not filed. So in a procedure of filing, although the filing starts at the various levels, it's a direct first complaint or an appeal, or depending upon the price of that particular good or service, or you have to take care of the limitation, respect the limitation period. And then if the judgment has come, it has to be enforced. And that also is something which is enforced through these laws. And there is also a filter operation which happens when you file the complaint, where it is validated to see if there is a complaint which is a fictitious complaint. So that is also the role of these agencies, where they discard such complaints. So what happens because of this is the consumers are empowered because of all these definitions and the laws and the updated laws which are brought into the consumer protection law. So this empowers the consumers. Then there is a protection against the exploitation. So although they're empowered as a customer to seek recourse for any kind of grievance, which help to play, have a field for you to go and even fight the largest corporation or smallest of the business, then protection against the exploitation is something which is very, very important. It is also helping you to not getting exploited, and reduces an opportunity for the companies to exploit you using the unfair trade practices, etc. And in another way, it also helps you to encourage the fair business practices. The fair business practices also has to be is promoted because of the presence of such a body, which is a deterrent. And this, as we said, the councils, which is part of these bodies, is also working on the awareness and the education. Say, for example, you purchase a washing machine, it malfunctions shortly, which I said shortly. You go to the place where you have bought it, or you go back to the company who has purchased manufactured it, and they come back and say, we don't want to give you fix your machine, or we don't want to replace the machine, although they promised a replacement warranty for 1 year. So you file it, then you complain with the manufacturer, and the company refused. And under customer protection law, then the consumer can seek a redressal to either take a refund, you want to return the machine, get your money back, or also get money for your aggravated situation where you have been, running pillar and post, paying the cost to the lawyer to fight, and etc. Or you want to have a replacement, a different machine is replaced. You still want to go by that machine, you can have that. Or if you want, you can just ask for them to fix that machine for you by replacing any faulty machine part. So either of that option is available for you in case of the consumer redressal, depending upon what you wish to have and what is right to do. For example, a restaurant, you go there and somebody serves a raw food to you. The vegetable or the meat is raw. It is not very well cooked. And when you eat it, was not properly cooked. You fell ill. So then you can file a consumer complaint to get a relief, so that because of this kind of unfair trade practice by not having a right quality control of the food, you can seek a compensation for the medical relief. So the very famous case laws could be for the consumer protection is Indian Medical Association, IMA. So Indian Medical Association versus VP Shantha. VP Shantha, Shantha, 1995. This was a landmark judgment in history where the medical service provider was held liable under consumer protection law, recognizing a patient as a consumer in the context of medical services. And it was the very first case where it was done strongly, and it is emphasized the importance of service quality accountability in the healthcare sector. So this was a landmark judgment which put a very strong presence of consumer protection redressal in the areas of the healthcare sector. While Lakshmi Engineering Works versus PSG Industries Institute is another case law. Lakshmi Engineering Works versus PSG Industrial Institute, 1995. In this case, the Supreme Court held a manufacturer that the manufacturer owes a duty of care to the consumer, and failure to meet that duty of care can result in liability for damages. And under consumer protection law, this case highlighted the obligation of manufacturer to ensure the product safety. So product safety is mandatory obligation for the manufacturer, which was established by this particular case law. So that's all about this part of the section as well. Module 9.